Thank you, Mr. Faulk. The floor is yours. Welcome.
Thank you, Mr. Chairman and members of the committee.
Put the microphone on and pull a little closer, maybe.
There we are.
Speak up like the previous witness did really good.
Absolutely. Absolutely. I want to thank you, Mr. Chairman, and your sense of humor, and the members of the committee for inviting me to speak to you this morning. At the outset, I want to note that I'm not appearing here on behalf of any client or any organization. I've responded to the committee's invitation as a concerned citizen, and I'm going to provide information based upon my experience and my observation. I am the Senior Director of Energy and Environment Initiative at the Law and Economics Center of George Mason University, where I develop and participate in forums designed to promote constructive dialogue regarding our nation's energy and environmental issues. I'm also a partner in the Washington, D.C. law firm of Hollingsworth, LLP. I've become familiar with the sources of the Environmental Protection Agency's alleged authority to veto permits issued under Section 404 of the Clean Water Act, as well as the disputes that have arisen recently regarding the extent of the authority both before and after permits have been issued by the Corps of Engineers, which is, of course, the primary authority responsible for such actions. Based upon my review of 3 situations that have arisen recently, I believe there's an urgent need for a comprehensive inquiry into whether the current statutory structure can be properly construed to authorize retrospective and prospective vetoes of legitimate business activities. The risk presented by such vetoes can be examined in these 3 situations that I've mentioned. The one, which has already been discussed at length, involving the Mingo-Logan Coal Company, Spruce Mine Number 1. The second being the Pebble Mine project development in Alaska, which involves a prospective veto. And the third that I'm aware of is a request that was made in May 27th, 2014, to the EPA by a group of Native Americans in Wisconsin who are seeking a prospective prohibition of exploration and extraction by mining companies, particularly the Gogebic Talconite mine, for protecting the water resources associated in those situations. If the congressional inquiry that I'm requesting this committee to recommend reveals that these risks exist, Congress should consider amending the Clean Air Act to preclude these problems. These amendments should require that the EPA's objections and withdrawal of specifications occur only during the normal permitting process, not before the permitting process is commenced and not after the process is concluded. Without these protections, these practices, which are enhanced by deferential judicial review, unreasonably expand the EPA's regulatory range and threaten to upset the delicate balance of powers and participation necessary to ensure the administration fairly of the Federal Clean Water Act. It's worth noting that with respect to the Mingo-Logan situation, that in the Supreme Court an argument was made in the petition for certiorari that the Supreme Court has already decided the question under the Core Alaska case, which is cited in my materials, that the Corps of Engineers is entitled to full respect for its decisions and that they, in fact, have the authority to deal with these issues during the course of the permit issuing process. And that case can be found at 557 United States 261. It was decided in 2009. But aside from these legal arguments, there's a multitude of economic issues that should be addressed here. Given EPA the unconstrained authority to revoke section permits at any time strips the permits of the finality and regulatory certainty that Congress clearly intended for them to have. While the Corps is required to consider the impacts on investments as a part of its issuing process, it's interesting that the EPA claims it has no responsibility to consider these investment opportunities. Certainly, there is nothing in the Clean Water Act that suggests that they must do so, and therefore they have a situation that is left to their complete discretion without even considering or affording any deference whatsoever to these important issues. Permits are extremely important, and regulatory certainty is extremely important in all these situations, and the threat of deferential judicial review is also a problem. As we know from the recent decisions of the Supreme Court, all these issues are entitled to dispositive interpretations. EPA's interpretations are dispositive under the Chevron issues. They receive all sorts of recognition. Scientific issues are entitled to an extreme degree of deference. Under those circumstances, you can see that the danger of this situation, which deprives parties of opportunities to challenge these issues in the permitting process adequately, necessarily precludes any meaningful review of these issues by the courts.
Thank you. Take this so far, thank you, Mr. Quinn or Mr. Faulk, on the expansion of the EPA's rule on the waters of the United States. It seems to me that there's a possibility there will be a lot more requests for Section 404 permits from all types of different entities, developers, farmers, local governments, townships, all of it. Did you see it that way, Mr. Faulk? I guess.
Yes, I really do. I think we're seeing an effort by the EPA here with these proposals to basically bring in basically any place that connects in any way to waters under the United States jurisdiction to be extended. And we will see farmers, for example, who withdraw water. We will see other businesses that withdraw water that are from these things come into the regulatory process. We're going to see a surge of applications for these permits, and all of these people are going to have to rely upon what those permits say in the process of planning their business activities on a daily basis. And if it becomes uncertain, the question of how much they can invest, how big their businesses can grow, how intense their business activities can be.
I want to give Mr. Kovac a chance to, I think you want to talk about that too, I think.
To the witnesses, thank you. Mr. Faulk is a George Mason Law grad. Thank you for being here. I had a quick question for you. Is the prospective veto authority just zoning by another name?
I think it could become that as EPA is applying it, because in fact, what can happen here is they withdraw whole swaths of land and watersheds out of consideration for permitting activities, then you're basically precluding any sort of exploration, production, mining, extraction, or any other sort of useful activities taking place on that piece of land.
Do you think 404C should be changed?
I think it should. I think it should definitely be restricted to require the EPA in this extensive permitting process to make its objections known then, to say why now afterwards really presumes the fact that they didn't have an adequate opportunity to make their points known.